Fine. Can you please
Yes, sir.
can you please introduce yourself first?
Yes, sir.
That is the bare minimum everybody would like to know because there are so many people.
Okay, sir. Okay, myself, Varun Gadvi, sir. I am an
Ji.
advocate here at Gujarat High Court. Uh,
Mhm.
I actually attended this initiative last year also, and
Okay.
I find it very nice learning as a learning prospect, on a learning prospect.
એવું છે એટલા બધા વકીલ મિત્રો આપણે ટ્રાય કરતા હોય છે આ બધી એક્ઝામ ક્રેક કરવાની કે even if one doesn't get selected, it adds to the experience. વકીલાત કેવી રીતે કરવી એ ફાવે પછી જજ તરીકે કામ કેવું થાય તો ઓટોમેટિક ફાવે. I hope as most will be from Gujarat, should I continue in Gujarati or in English? What is your preferable language? Preferred language? What is the choice of all participants? Should I speak in English or should we continue in Gujarati? And if there are some people who do not understand Gujarati,
Sir,
should it be Hindi?
I think yes, it should be Hindi as most of them might.
No issues. Then we will continue in English so that those who are in Gujarati medium should know the importance of English.
Okay, sir, as you say.
Anybody else except Mr. Gadvi? Shall we start, madam?
Yes, sir. Over to you, Amit.
Uh, Good evening, sir. Good evening, sir, and to everyone present here. I, Avneet Kaur, delegate of Sambhav Initiative and moderator of this event. On behalf of organizing committee, I extend a warm welcome to our esteemed dignitary, Shri Brijesh J. Trivedi, sir, and to all the participants in this seventh day of 10 days online national capacity building program for civil judges examination of Gujarat State Judiciary, jointly organized by Sambhav Initiative, which is working towards alternative dispute resolution, free legal aid, mental health, and creating legal literacy under the direction and guidance of Pattern-in-Chief of Sambhav Initiative, Honorable Mr. Justice C.K. Thakkar, Sir, former Judge of Supreme Court of India, and Patron of Sambhav Initiative, Honorable Mr. Justice M.R. Shah, Sir, former Judge of Supreme Court of India, in collaboration with Gujarat High Court Advocates Association, which is a voluntary organization formed by Association of Advocates regularly and ordinarily practicing in the Gujarat High Court with a purpose to promote the professional goals, objects, and interests of advocate members in general, and is led by managing committee which shall have total 15 elected members. It holds legal seminars and study circles to keep the member advocates updated with the current legal developments and Advocates Care Society, where today's session is all about the bench and beyond, expectations from a judicial mind. Before we start the session, please adhere to some webinar etiquettes. I request all the attendees to keep their microphones muted during the session. If you have any questions, please use the chat box or raise your hands. It is my privilege and honor to introduce our esteemed dignitary, Shri Brijesh Trivedi, sir. Advocate Brijesh Jaswantray Trivedi, sir, is a senior legal professional with over 3 decades of experience. Sir earned his LLB from Gujarat University in 1989 and has been a practicing advocate since his enrollment with the Bar Council of Gujarat in July 1989. Currently, Sir is serving as the elected president of Gujarat High Court Advocates Association and is also the standing counsel and advisor to the Bar Council of Gujarat. Sir co-authored legal articles published in the Gujarat Law Herald. Sir has appeared before the Honorable Supreme Court of India, various high courts, including those in Mumbai and Kolkata, and numerous courts across Gujarat. Beyond his legal work, Sir is the founder of Advocates Care Society and a registered trust supporting the legal fraternity. Sir has actively supported NGOs like AWAG through street plays addressing social issues, especially women's rights. Known for his leadership, communication skills, and dedication to service, Advocate Trivedi upholds the values of nation first and Vasudhaiva Kutumbakam, firmly believing in the supremacy of the Constitution's preamble in its true letter and spirit. We are deeply honored to have you with us today, sir. Over to you, sir.
Dear friends, hope there are no other senior dignitaries present because they would not like to now re-study the entire thing which they have served with all their expertise. Honorable Mr. Justice Thakkar and Mr. Justice Amar Shah both have been great judges of Gujarat High Court, and Honorable and then Justice Thakkar was elevated to two different High Court Chief Justices before being elevated to Supreme Court, and Justice Amar Shah was elevated to Bihar High Court, Patna High Court as Chief Justice, and then from there, his Lordship has been elevated to Supreme Court. Both have now retired. Both have been serving the system even after their retirement. Welcome all. Welcome Hiranshi-ben, Avneet-ji. Avneet-ji, let us be very clear. So far as my lecture is concerned, it will be different from all lectures they have ever taken. Rest assured, it will be different. Anybody who would like to ask in the middle of the session can simply, as Avneet suggested, can jot down their question. We will have a long question answer session. Don't worry. Everybody will be permitted to ask questions. Now, my topic is slightly different from what you have been listening since last about 6-7 days. All legal luminaries have been telling you what to read, what not to read, what is to be prepared. Mine will be a different exercise. What I am emphasizing has been taught over the years. I have heard my father, the late Sri J.T. Trivedi, writing as many as more than 12 articles across his illustrious careers of writing more than 50 articles on judicial subjects. 12 to 14 have been about judges and what they are required to do. I'll be using his book to earmark the qualities of judges, which I got published under his legendary title, Am I a Maverick? A question he always posed to himself. Am I a Maverick? Maverick means a person who charts his own path. He doesn't chart the path traded by everybody, but he has his own ways. There are many articles. Are the courts casinos, etc.? These you people will come across as and when you keep maturing in the profession. There are some senior people here also. Some might have come across also who are in High Court. Now, the main issue which decides a person's character as an advocate, because we are all advocates for the life. Judicial service is a vocation we choose for 2 to 3 things. One, those who are finding it difficult to get regular clients they like to opt things. One is people. Just a moment. This is the main difficult part when one is a busy advocate. Constant disturbances till 8:30. This is the time people call us. Now, the main issue which we face as an advocate is the first-hand experience how to extract facts from the person who comes to us, because he is the master of his facts. So, first thing as an advocate we must know is the facts of the case which the person comes with. If we master those facts, just like the person himself, nobody can make allegation of suppression of material fact, because the other side against whom the cases are being filed are well aware of all the facts. Most of the facts with the person filing the case is aware about. So first thing as an advocate we learn is to how to interview our own clients, how to extract things. There may be some time when we have to rush to save the limitation in money shoots, etc. We have to be cautious even then, not to miss out important aspects so that nobody can make allegation of suppression of material facts. So whatever may be the urgency, as an advocate, one must know how to extract facts from the client. Now, those advocates who are directly trying after the examination have got a job that now they have to wait for 3 years. So fortunately, again, the system has gone back to the original system of inviting only those who have minimum 3 years experience as an advocate. So usually, either a person having senior, he must have, say, remain present and heard the senior asking the client how the facts are and what they are. And then he will select what to say, how to say, when to say. There are three stages. There are some facts which can be said at the time of filing further affidavit or affidavit in rejoinder, etc. So there are stages one should know. Now, once having achieved that experience, as soon as one is selected as a judge and undergoes the training, the first thing he should ask his judicial mind is that why this person is filing this particular suit. When reading the suit at home, because everything comes a day earlier in the routine manner at home, which is known as labai. But there are cases in civil courts which are filed in the morning and are required to be placed urgently before the court immediately after recess. And sometimes, even with all the say diligence, the office is unable to place it before the judge, before he takes the seat in the second session. Under such situation, the judge should not be say bogged down by the urgency shown by the advocate. He should be very careful in reading the entire say basic facts. And if the registry has not raised certain objections which are legal, and as you must have been by now aware about Order 7 to 11, what are the duties of a judge on his own without waiting for an application from the defendant who are not even issued any notice to see under Order 7 to 11? The judge himself is also competent what to ask and how the questions to be put, whether it is within the limitation. That is the basic thing the registry must have done. Then whether it is not against any settled principles of law or any law in force in India. So these are the basic things a judge should cursorily and quickly go through and then hear the matter patiently. In important cases where unless the stay is granted, the matter suit will become infructuous. They should not be shy of granting status quo, which usually we are seeing nowadays. The practice has become that first let me issue notice, even a short notice. Sometimes a short notice also changes the entire scenario at the site. And there is question of somebody trying to encroach upon. And if he is granted a notice, he will not wait, he will directly encroach the land with help of say people, and then he will make a show that I am in possession. So there are situations where judges have to be very, very cautious. One should not also be at the same time taken away. Oh, such a serious thing. One has to apply his judicial mind coolly. Few salient features a judge must possess. He should read, and read, not law, not only law, but he should read literature in whichever language it is available and known to him. Preferably, everybody who is shy of, say, possessing some knowledge of English should start mastering 10 words a day, 10 new words a day. Use it in sentences 3 to 4 times a day and then leave it. It will remain in their memory. And this is a word. So once you have the requisite knowledge of language by reading classic literatures, you will achieve 3 goals. Command over the language, how to write small sentences with direct effect of using proper and appropriate vocabulary. The words are very important. Sometimes if you go through some judgments in our vernacular language from trial courts, the difficult part is that the entire paragraph does not have any comma, full stop or anything. So grammar, grasp of grammar and how to put everything concisely with complete clarity can be achieved only after reading great authors. Whatever you read, even if you read magazines, you will learn something. Sometimes you may also learn what not to write, how not to write. So the first thing one should read as an advocate, trying to become a judge or to become a good advocate, is reading of the literature. Those who are already become advocate will find it difficult, and having some practice will find it difficult. But do spare at least an hour a day. In our days, I used to read at least 100 novels a year. 100 novels of more than 100 pages a year. And then would repeat some extraordinary world classics. Because that was the habit which my father imbibed in me my elder brother, and I am in turn in my children. That will be of very great help. It will not only open your mind to the entire world, how the people behave across the world, across the ages. Because usually these novels or dramas are periodical. Some are written in 1800s, some are in 1700s, in Shakespeare's case, 1600 and something. So this will give you insight of human psychology, human behavior, and all laws. Take my word, all laws are based on common sense. As a normal human being, whatever we feel is wrong, usually you will find that thing wrong in all the law books concerning that kind of thing. Suppose we are going on a highway and we find somebody coming in our lane, which is the wrong lane for him. We need not even bother to know the law. It will be a wrong thing. Likewise, for any normal person behaving normally, his sense of right and wrong would be the law of the land if we search the law on the topic. So, to grasp the law, one has to use the mind of a common person. And authors have rightly said, common sense is very, very uncommon and it is becoming rare. So, first of all, after reading the classics, literature, dramas, poetry, prose, say, essays, novels, even say novels which are having absolute no value in literature but are grasping novels. Everything should be read. Justice Shakkar used to say when he started practice that my only reading outside law is law books and Gujarat Samachar. Then he started reading, and if we read his books, we can understand what command he achieved over language apart from the normal law, which he has to obviously take it from the law book. That what is the section, so he will take it from the law book. But the elaboration which he used to give in his books will show how much learning he achieved during his practice. So this is how you become a good judge. And some people become great judge because they read. Usually we see that those believing in left ideology, that is communist people, they are very avid readers. And therefore Justice Krishna Iyer, who hailed from Kerala, being a person with absolute mind for a common person, his judgments were very, very short, but it gave in-depth study on the topic and they were great judgments. The language he used, what a horrendous enterprise it is. It can come only from a person of level who has read literature in detail. So first of all you should do is to concentrate, keep your window of the mind open, as Gandhiji said, to let the civilizations of the world to blow in and work very coolly. There will be irritating advocates, hopeless, say, drafting. You need not get disturbed. It is bound to come. Just as advocate, we feel that some judges are not up to mark and we can't express because of the threat of contempt, etc. And we have to keep on saying that Your Honor is well aware, Your Honor is well read, Your Honor must have come across the judgment. Most of the time, it is not so. So, a person in his lifetime where more than 20, say 30, 40 High Court benches are working, Supreme Court is working, it is impossible to go through each and every important judgment passed by honorable judges over the years. Before we were born, the system had more than lakhs of judgments. So to find out the most important judgments of each era on all topics is a difficult task. To remember them, it is also a very difficult task. So start reading very important judgments. The second important thing is Order 37 once you enter the judiciary. Order 37, some say it is a code in itself. It takes care of summary shoots to be filed. So what are summary shoots when we learn in civil procedure code? What are long cost shoots? They are civil shoots. So even long cost shoot in CPC, they give very short time, but unfortunately because of lack of number of judges and lack of grasp of civil law and habit of advocates of taking time, has created a situation which has created havoc in the Indian legal system. Today we see lakhs and lakhs of cases pending. But pendency in your own court should not give you so much pressure that you forget the topic at hand and you keep on thinking that, oh, I am having 2000 civil cases. Nowadays, judiciary strength is increasing, so work is going to get distributed. But if you have a cool mind, you will be able to work more quickly. My brother, who was asked to become a high court judge, chose to be a city civil judge. And within a period of 6 months and odd days, he gave 800 judgments. So that gives the idea that if you are well read, well versed with the system, and you have the habit, nagging habit of studying properly each and every case at hand, you will be able to grasp the system. Give date, 1 or 2 date, be liberal, but not so liberal that you are taken for granted. So you have to be tough, but at the same time smiling. You have to be cool, well read. If you have not read and understood the matter, you can also take time. And let us have it this week, next week. Go through the matter, try and grasp the controversy at hand, and then you will be able to deal with it properly. The evidence will come, and on the basis of the evidence, now this is the crucial juncture. Before every court in civil and criminal matter, there will be witnesses, and with the how the witnesses behave in box, that and what they are telling is whether it is truth or not is to be adjudged by the judge himself. A good judge will be able to grasp the tenor, tone, body language if is well read and he has the nick of grasping what is passing in the mind of the witness. Nowadays, what we see when the witness is in the box, the steno is typing, the judge is doing some other work to cope up with the work. Don't do that. Concentrate on the witness. Don't poke your nose because there are advocates for both sides. They will take care of the witness. If there are objections, the other side has engaged the advocate to raise the objection with regard to compound questions, etc. So grasp the evidence act that how the witnesses are to be treated in the box. Don't force them to say only yes or no. That is the duty of the advocate who will try to pressurize the witness in all the manners. Permit him atmosphere which is not hostile to the witness. Then you will be able to gather whether the witnesses are telling the truth or not. Because suppose both side witnesses are strong enough and give good evidence for their respective sides, it will be for the judge to judge the demeanor of the witness, how and what they said, and judge it with oral and documentary evidence. So it is a very difficult task. If you are a judge, you have to find out the truth, and truth is the journey. In Maria Margarita the Sequeira, the Supreme Court has very elaborately described that all civil or criminal suits are a journey for finding out truth. So keep that in mind. In the trial court, you will have the opportunity to even visit the site. Don't hesitate. Always if somebody gives application to visit the site, don't send somebody else. Try to do it yourself so that you will grasp the reality at the site. That is an experience as a judge one should always take. One should not be shy. No, I will only sit in the courtroom. I will send my court master or court register or some senior advocate to go. There are applications for local inspection by judges also. If somebody is well, grasped with those kind of provisions and use it, try to do justice by visiting. That will give you an edge over the other judges who do not follow that practice. So this is one of the main things. Now my father, in his article, Selection of Judges, a Hamlet right, problem. He saw to it that all ingredients of a good judge are brought in the article. Just a moment. There are some real good features, and the preface of this is written by none other than Honorable Mr. Justice C.K. Thakkar. My father was a very, very close friend of His Lordship. What is expected of a good judge? A judicial temperament. Just a moment. In the other book which I was having day before yesterday on the first session is not here. Yes. It is a longish article. Now, the ingredients which he has taken from C. Dale McClaim that one should consider when voting for a judicial candidate, because in America, in higher judiciary, judges are selected by voting by the judges and elected members. They are aptly necessary for selection of judges are legal ability. Legal ability is having the intellectual capacity to interpret and apply established legal principles to factual situations and to communicate in speech and in writing the reasoning behind a legal conclusion. A judicial candidate should have the ability to reach concise decisions promptly, respond to issues in a clear manner, and grasp quickly the real meaning of the questions presented. So, when you are presented with a civil suit and the written statement is filed, you will find what issues are raised by the plaintiff in principle and are opposed by the defendant in his written statement. And those issues you should frame the questions and then evaluate the entire evidence, oral as well as documentary, with this ability that settle principles of laws, actually how it is applicable to this particular case, etc. Trial or other similar experience that ensures knowledge of the law and courtroom procedures. A judicial candidate's professional experience should be long enough so that one can evaluate the candidate's performance in dealing with legal problems and the judicial process. While substantial trial experience can be a plus, other types of legal experience also should be considered, such as negotiation and mediation skills. Nowadays, as Sambhav Initiative is rightly saying, that it is also running lectures for mediation, arbitration, conciliation, which is an in thing in the entire system. Originally, it was there, then the European and Western countries took lead in creating mediation. They have made their legal system so expensive that people would opt for mediation, and it has resolved the say pendency of suits in a very large number. While substantial trial experience can be a plus, other types of legal experience also should be considered, such as negotiation and mediation skills. Lawyers in private practice, law teachers or corporate, government or public interest lawyers, or others who are not frequently in the courtroom might have experience that would make them successful judges. So all type of judicial work one should accept when he is an advocate. So it will expand the horizons. Third, a record and reputation for excellent character and integrity. Nowadays, we are, because of these modern technologies and news, we are hearing about corruption in judiciary, people who are not, say, up to the standard of integrity, corruption in cash, corruption in kind, loose character, all things should be avoided. It is said the integrity of a judge is the keystone of judicial system. Integrity enables a judge to make decisions based on the facts of a case and the law. A judge with integrity sets aside personal prejudices, personalities, and partisan political influences. Every judge is a human being. One will have his political ideology. Nowadays, nowadays what has been uh, the mind of people, hatred. No religious hatred should be there. We should strictly work in accordance with our preamble in the constitution, and we should treat each citizen not by his religion, caste, creed, but on the facts of the matter. Financial responsibility. A financial responsibility in a candidate shows self-discipline and the ability to resist pressures that might threaten judicial independence and impartiality. We are hearing about corruption, offer of corruption. We should resist. Nowadays, the pay scales have gone high. It will keep on going higher. But what judiciary needs is a very clean judge. A judge who is not lured to see everybody is interested in earning money. And if you want to keep earning money, try to remain a good advocate. It will give you tremendous amount of money if you are capable of earning. And if you can show your capabilities in the open court practice as a lawyer, people will come to you. But once you enter the judiciary, resist the temptation as offered to you by touts and some advocates who have already ruined the reputation of judicial system. Check whether a candidate has had the judgments and liens or bankruptcy proceeding instituted by or against him or her, and whether the candidate has promptly and properly filed all required tax returns. Judicial temperament. A candidate should show qualities of patience, open mindedness. Sometimes we are very hasty in making up our mind. Don't make up your mind till the last word is said by the advocates in their concluding arguments. Don't try to prejudge everything. Oh, this must be so. Things may change at any moment in a trial. So it is said open mindedness, courtesy, tact. One has not to lose firmness while possessing all these things. Firmness, understanding, compassion, and humility. A candidate should be able to deal with people calmly and courteously and should be willing to hear and consider the views of all sides of a case. A good judge needs to be even tempered, yet firm. One has to remain firm all the time. But firmness has to be with a smile. Open minded, yet willing and able to reach a decision. Confident, yet not self centered. One has to come out of one's own, say, predicaments in mind. One should not prejudge, oh, it must be so. I have heard it from my childhood. It should not be. Mental and physical capacity to fulfill the duties of a judicial office. Because see, why this is necessary. Once you will enter the judiciary as a judge, you will know, oh, we are 5 meters or 10 meters a week. The judge is 100 meters a day. A candidate should be in good mental and physical health. Good mental health also includes an absence of erratic behavior that would affect the candidate's ability to be a fair and impartial judge. A record of community involvement. A candidate's non-legal experience is very important. A candidate's participation in public service, community, and pro bono, providing free legal services to the less fortunate activities should be considered. This is for the system, how they have to select. Administrative ability. A judge needs to have strong administrative skills to deal with the demands of long court lists and complex lawsuits. Apart from that, when somebody becomes judicial magistrate first class, one has to be very cautious and personally go and check muddamal room very regularly, because if something is found missing, the responsibility is not that of the person who keeps the key. It is that of the judge. So judge has to be very careful in managing the administration under him. He has not to put blind faith in the staff. Most of the staff in Gujarat or everywhere is good. But there are some black sheep who will take advantage of if the judge shows some, say, haste in signing everything without reading. One has to read. Even if there is less time, one has to read what he is signing. Whether he is signing the Rojkam of particular matter, written in the manner in which it should have been written. Otherwise, many judges are removed from service after departmental inquiry when the Rojkam is tempered. So be careful. once you become a judge. I have defended one judge where 3 different Rojkams were placed on record and he was removed from service. That came to my, say, advantage. I was able to prove that none of them were actually original. Original was something different, and that's how that judge was reinstated in service. Record of co- devotion to improvement of quality of justice. A candidate should participate in proposing and supporting ways to improve or preserve the legal system through active membership in local, state, and national professional associations, such as bar associations. Demonstrated sound judgment in professional life. A candidate should possess good work habits and ability to set priorities. A candidate should never should meet deadlines, keep appointments and commitments, and respect the time of parties involved in the lawsuit as well as the lawyers, judges, and court personnel. It may be pointed out that there is another publication which gives a list of qualities that should be identified and then sought after in selecting the applicant. Judicial temperament. I will not dwell deeply so that we can have question. Then intelligence, ethics, courage and integrity, experience and education, suitability to workload, continuing legal education. See, every day before going to sleep, at least I find out 20 important judgments passed during the say last day or last week, and then if they are not earlier posted, I do keep posting. So by posting it also, even without going in detail, I generally remember that if you want 138, go to my links and you will find out it was posted before 3 4 days. So that we every day legal education is one of the most boring subject because every day new judgments will come, which will set earlier judgment aside or substantiate the earlier judgment and emphatically lay down something more. So we have to keep up to date with technology and everything. Civil and professional responsibilities. His health should be very good. His character should be impeccable and beyond doubt. This is how, if you go on reading, reading makes a man perfect. Read, read, and read. Read whatever you find. Don't wait for the proper book to come in hand. If a book has come in your hand, go through it. At least you will learn some new words, usage of the word which you might be using in a different context. So the command over the language, once it will improve, your ability to write a very good judgment will also improve. So what you should do is to understand the procedural laws, the substantive laws, like the say CPC is there, but specific relief act, and whatever basic law which lay down the definitions of suppose in crime. Now we have Bharatiya Nyaya Sanhita. Previously it was Indian Penal Code. So likewise, all actual say Contract Act and Partnership Act, all basic laws, fundamental laws you should grasp. Procedural law you should master, but be very careful. Procedure is handmaid of justice. Don't bog down through procedure. If some procedure is missed by the advocate, be liberal. So now I think enough is talked about reading, and reading, and the qualities of expected of a good judge. And now we will open it for question answer because I want to give you full time. You have to do two things before asking the question. Introduce yourself and open your video so that we can see.
Thank you so much, sir, for your wonderful session. Now we open the floor for question and answers. Whosoever have any questions, you can ask your questions directly from the sir or raise your hands.
Participants
Even
also have a question. Now you can unmute yourself and ask question to the sir.
don't feel shy. See, ask the question if you have any questions in mind. Otherwise, our professor gave one very good example. While we were studying LLM, Mr. Mukesh Bhai Shah a great personality. Mukesh bhai asked us the question in the first lecture. We are as silent as you people are. So he gave an example that a Chinese army general came to visit a team of soldiers and he asked one person, "What's your name?" So the soldier said, "Anything you say, sir." So he said, "It must be either she or Wa." Initially it was she, but then my father changed it to Wa. "When were you born?" "Anything you say, sir. Either it must be summer or it must be winter." The answer came quickly that I was to born in winter. When I started coming out, it was so cold. I went inside back and came in summer. So don't feel shy. Ask the relevant questions. Just introduce, please. Madam, your section 142, etc., all these expert things will be answered by people who are taking particular lecture on the subject. My topic is just how to enrich yourself to become a good judge. I can certainly give you answers on 142. There are latest judgments also, but it will be boring thing for others who want to know what to do to become a good judge and how to get selected by your performance in the exam and oral interview. Or you can ask me later on after 8. My number is available. My number you can get it from even the administrator, and everybody who want to take it can take it right now. It is 98252 69434. Or on any low topic and particular session or anything, you can ask me later. Those who want to ask question will have to unmute themselves. And if you don't have question, I can continue with other aspects which are stress. Yes, there is one question from one young person: how to deal with stress? See, everybody has a different level of resisting the stress. One has to be work. One has to work very fully, efficiently. Efficiency will come if you have grasped the law and topics on law, and you are well prepared on the subject. If you are not well prepared, you can always say, I will give the number again before leaving. You can always say that we will have this matter after 2-3 days. Go through the facts. Stress will be there. As a judge, stress will be there. But to overcome the stress, one should not lose the equilibrium, as it is known. One has to keep the cool. Already, your predecessor was under full pressure to complete the work in time limit. High Court and Supreme Court and higher judiciary, suppose you are in trial court, and district judges will also give you deadlines. But you have to meet the deadlines very coolly. If you act in a jittery manner, or if you remain under stress, your workload will say be more than less. Because if you are keeping your cool, you will be able to judge things very quickly, very nicely, with a smiling face, and there won't be any complaints. Because if you say give respect to the other side, that is the advocates who are seeking quick justice, they will also respect you, they will also try to understand, but don't make it a habit of giving it as a reason. Oh, sir, I wanted to complete your matter today, but no, because of that, however, everybody is well aware that there is a heavy workload. The other earlier judge could not complete even if he wanted to. So be very calm. You have to have a very strong mind to resist the pressure. Any kind of pressure, either from your superior or from the system, should be avoided, but at the same time, it should never look that the judge is not interested in kind of work. Besides, you have to give at least an hour a day for your mental and physical health. Don't be under too much pressure of work so that it will directly impact your healthy lifestyle. You have to, if you are maintaining a good health and good mental health by, say, mediation, keeping your eyes closed, even without mediation, Think coolly, freely. Don't think about law for an hour at least. And then you will turn out to be a very good judge. Keep your cool, fix your work timings. Don't stay very late up, wake up early, concentrate, and then think about the matters. Put your system in place. Even if you don't give time, don't waste time in adjusting the board. Board will get itself adjusted. Those who want to mention in the morning, permit them to mention. If they are not much interested in urgency, attend to those matters wherein litigants are in courtroom and they want to proceed. By adjusting the board, people are wasting 1 hour a day. Stop that. Adjust it within first 10 minutes by giving opportunity to all to mention. And if you find the reason genuine, give them in say old matters, give them short time. In new matters, you can give them the date of their choice. But then concentrate on the work at hand, people who have come. Preferably, you can only adjust that, okay, there are 3 people who are ready to be cross-examined. Let us have them in the afternoon. But don't avoid it in such a manner that on the next day you would not like think of coming. Okay, if I don't go, the judge is going to give time. So act as per the say heavy workload, which is now the order of the day or rather disorder of the day. Try to cope up and quickly dispose of short matters. It will give you tremendous time by the time you are settled in a new place, and then the workload will reduce. Yes. Somebody wanted my number again. This I am going to tell at the end of the session. Please, any other question?
There is a one question in the chat box that in case of conflict between moral ethics and official duty, how to handle this situation?
Moral ethics on legal side has to be given preference. We have to abide by our ethical morality. We can't go beyond the legal system. And even if our superior judges are trying to pressurize us to work in a particular manner, we have to resist that. One person was dismissed when a sitting high court judge wanted him to pass an order in a particular manner. Madam, instead of writing message, please ask the question, Krupaliji. So what happens is that if there will be outside pressure as also inside pressure. There will be advocates who are cantankerous, who are powerful in their local, say, places. They will try to put pressure. There will be elected body members who would want you to pass particular orders. You have to act only in a legal way. No moral conflict should be permitted. If you are involved, suppose there is a matter wherein there is some distinct also conflict of interest, then you have to leave the matter by making it very, very open that against this company, I am having shares of the company, or here is a person who is known to me. So as to avoid any kind of controversy during your entire tenure. If you are clean by heart and you will explain in the beginning that yes, this person is known to me, but I am going to decide in only judicial manner. If you have faith in me, I will keep the matter or I will leave it. Do it in the beginning. Don't give advocates the opportunity to point you that there is a conflict and this is how we are behaving. So if they, I think Virenji, anything else you want? More clarification?
No, sir. Also, sir, some question
One of my client is going to keep on
in
calling.
the chat box of Krupali ji that sir,
Yes, she wanted to ask something. Yes.
yes, Krupali ji, you can unmute yourself. Sir, I read her question that to increase the legal knowledge and English language, sir, can you suggest any magazine or book for the same?
Krupaliji, you will have to unmute. Do you use Google?
हेलो
Krupali Ben,
हाँ हाँ बोलो सर
do you use Google?
यस सर
Write in Google right now.
ओके
Test short stories.
Okay.
short stories
Short story.
of the. So you will find short stories in the world. So you will find that of Shakespeare compilation, world best 50 short stories, world's
Okay.
100 best short stories. You start reading small things. If you feel
Okay.
the language high, keep maintaining a diary. Any word which you have come across for the first time, write down. Write down the name of the book, the author, the story name, and write down the sentence in which it is used. Then
Okay, sir.
once you go to Oxford Concise Dictionary or Webster or Cambridge Dictionary, you will find different usage of the word.
Okay, sir.
Then once you learn that word by heart, previously aware, just a moment. Let me just answer him. Sorry, person requires this. So once you write down and learn one new word,
Okay.
you will find out that in English language there are 10 types of different usage.
Okay.
And once you keep reading, it will come naturally to you. Some words you may not say need to look into dictionary because in the context of the sentence you will understand the meaning, even if you have come across for the first time. So the basic thing is to read anything. Start reading English newspapers, say
Okay.
Times of India, Indian Express, the Hindu. Now everything is available online. Start reading Hindi newspapers, popular. Gujarati, if it is your language, start reading Gujarati newspapers. It will improve your Gujarati also.
Okay, sir.
And that's how you and start reading the classes. I just took down. I will just change my posture and I will reverse the camera.
Sir,
Just a moment. By going to Google, you have to write only this thing, and you will find out it is Manvini Bhavai, Saraswati Chandra, Gujarat no Nath, Bhadram Bhadra, Patanni Prabhuda, Saurashtra Razar, and many more. So this is how you get. But read whatever is available. Read anything. Read anything under the sun, and your language will start improving. Yes, sir.
Okay. Thank you, sir.
sir,
Yes, sir.
sir.
Yeah, please speak.
Sir, please kindly inform to the new upcoming judicial officer who is giving a examination.
Yes.
Basic nepotism are very widely spread.
દીપકભાઈ તમારો વિડીયો બી ચાલુ કરો. I will just explain three things. If you read the entire history of Indian judiciary, Tapodan Sahib, he has been
Yeah.
my client. દીપકભાઈ હવે વાંધો નહીં, હવે બંધ કરો. Judicial nepotism is there since the beginning of our independence. Those who were Supreme Court judges, their children have gradually become High Court judges directly without the say hard work you are required to put it to prepare. And that's how we still have only about 500 to 550 judges families from which higher judiciary judges are selected. There are always new entries, but they are in less in number, and gradually, even if they don't like, their children will also join judiciary as higher judiciary. So this is a problem universal to all systems, all fields. If you see acting, actor's son or daughters will come in acting. If you look at direction, director's sons will immediately work in that line. If you go to doctors, doctors son will try to become a doctor. If they are unable to get admission here, they will go to Russia, Ukraine, and many other countries where even less percentage people. And unfortunately, in our country, even up to 30 years, we could not do away with, say, a reservation because we continued the harassment on those who were already, say, downtrodden since more than 5,000 years of our so-called cultural country. We had caste system. We praised them for thousands of years. When the constitution came and democracy came, when Baba Sahib Bhimrao Ambedkar said in the Constituent Assembly that let us have reservation for 30 years, let us bring them in mainstream. We don't want them in mainstream. Why? We have to welcome everybody. Everybody should get equal opportunity. And then we can insist that now only the quality of marks. And why we are having seats, limited seats? Because we don't have infrastructure. If 15,000 or 50,000 people want to become doctor, we have 30,000 seats. Why can't we improve our, say, basic structure? Say, initially, when people started becoming doctors before 300, 400 years, we didn't need those marks, a particular, say, minimum passing mark to achieve the entry level. Those who were really interested in the subject chose the subject, studied hard. Now we have a set system. Anybody interested in becoming a doctor should be able to get admission in medical irrespective of their percentage in a particular standard. Because the checking system is also in doubt. So we need to have a classic kind of people who are very genuine, who genuinely have the time. Do you know how much minutes are given to an evaluator to go through the entire paper written with 1 or 2 years hard work? 5 minutes, 6 minutes. What is going to read? So we should have a better system. A moderator, evaluator of an examination paper should be given at least an hour or so that what is written in 3 hours can be read properly in at least 1 hour, and proper evaluation should be made. That will solve all the other problems. Nepotism is a hard thing to crack, but whosoever is made a judge from the sitting judge's family should be thrown out of the same state to another state so that he will at least know. And all should get equal opportunity. The way in which you people are preparing for even the civil judge junior division or civil judges should know that you are working more hard than those, as Mr. Deepak has rightly asked the question, having connections. So don't keep that burning in your heart. You work hard. If you are not selected as a judge, a judicial candidate, at least it will improve your advocacy. So keep working hard. Anybody?
Anybody have any other questions? Yes.
સર વિડિયો સ્ટાર્ટ નથી થતો.
કઈ
Hello.
વાંધો નહીં શિવભાઈ
હા
તમારો સુંદર
જી.
ચહેરો અને ગોગલ્સ દેખાય છે.
સર જી જી જી
એ
સર.
બી કર.
હા સર ફર્સ્ટ ઓફ ઓલ સર થેન્ક યુ સર. આજે સાહેબ જે જાણવા મળ્યું ને સાહેબ અત્યાર સુધીના લેક્ચરમાં સૌથી સારું સાહેબ જાણકારી મળી છે.
એવું
હું
ના
સાહેબ
હોય. સાંભળો
ના
હું
સાહેબ
તમને
જી
અહીંયા એક મિનિટ એટલા માટે
જી
રોકું
જી
કે
જી
I can't speak on a particular topic for 2 hours.
જી
એક
જી જી
અને
જી
બીજું કે હું જે ફેમિલીમાંથી આવું છું હું ત્રીજી જનરેશન છું. મારી ચોથી
જી સર
જનરેશન વકીલાતમાં તૈયાર થઈ છે. અને I am the only one from my father's line who has not gone for judiciary. And
જી
it is
સર
a very difficult subject for me to tell you to go to judiciary, even when my father, his first junior, second junior, third junior, fourth junior, fifth junior, all males have become judges except myself.
જી 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 સર જી.
And
સર
Mr.
હું ભૂતથી
Abhishek,
પ્રેક્ટિસ
હાજી.
જી સર હું ભૂતથી પ્રેક્ટિસ કરું છું ભૂત સેશન્સ કોર્ટમાંથી ધોળકિયા એડવોકેટ્સમાંથી.
ઓકે
સાહેબ
તો તમે
મારો સાહેબ
મારા મિત્રને ઓળખતા હશો મિસ્ટર વિનીત ચૌધરી.
જી સાહેબ ઓળખું છું સારી રીતના સાહેબ.
જી.
એ પણ મને સારી રીતના પ્રેક્ટિસ રેગ્યુલર કરે છે. જી સર
જી જી
મારો સાહેબ ક્વેશ્ચન એવો હતો કે સાહેબ આપે જે
હમ,
ગુણધર્મ કીધા એ સાહેબ જે
હમ.
છે જજીસ માટેના એ સાહેબ ઇન્ટરવ્યુ પેનલ ખરેખર જોવે છે? જો જોતી હોય ને સાહેબ તો ખરેખર સારું છે. એ સાહેબ શું
તમારો
જોવે છે
પ્રશ્ન
ઇન્ટરવ્યુ પેનલ?
તમારો પ્રશ્ન તો એ હોવો જોઈએ કે વેધર they ever possess these qualities જે અમે પૂછીએ છીએ.
હા સાહેબ
એ
જી
તમે
સાહેબ
ને-
જી
તમે નહીં પૂછી શકો. ઇટ ઇઝ ડિફિકલ્ટ ફોર યુ ટુ આસ્ક ધેટ. પણ એવું છે કે they should know. See,
જી
તમારે જ્યુરિસ્પ્રુડન્સ ભણવામાં આવ્યો કે નહીં ખબર નહીં, પણ
હા
જ્યુરિસ્પ્રુડન્સ ની અંદર હવે આપણે તો આખો મનુવાદ ફરી વાંચવાની વાત ચાલે છે આપણા
જી
કન્ટ્રીમાં.
જી
ઇટ્સ અ શેમ.
જી
પણ મનુએ બધું ખરાબ એ નહોતું કર્યું વસ્તી વધારા સિવાય, ઘણી બધી સારી વસ્તુ કરેલી. એટલે જયારે ધર્મની વાત આવે, યુધિષ્ઠિર માટે પણ આવે છે, નરોવા કુજરોની એક થિયરી આખી આવી કે even when he was a person who always used to tell the truth, a time came, જે બેને પૂછ્યું ને કે મોરલ એથિક્સ ત્યાં ખબર પડે
જી
કે અશ્વત્થામાં હણાયો નર હતો કે હાથી, ત્યારે મોરલ એથિક્સ જતા રહ્યા. અને યુધિષ્ઠિર જો કક્ષાનો માણસ પણ આટલા પ્રેશરમાં આવતો હોય તો વી આર નોર્મલ હ્યુમન બીંગ્સ. Having
જી
said this, it is very unfortunate that, as Deepak Bhai rightly asked, there is nepotism. There is people who are trying to influence through connections. મને ઘણા પૂછે સાહેબ, તમે 12માં 37 વર્ષથી છો હાઈકોર્ટમાં, તમે હવે તો પ્રેસિડેન્ટ થયા. મેં કીધું મને ઓળખો છો એવું કહેશે ને તો જ્યુડિશરીમાં તો નહીં જ લે. મને બારે એ લોકોને સહન કરવો અઘરો પડે છે. તો
જી.
અંદર મને ઓળખતો માણસ આવે તો એને તકલીફ પડે એવું એ લોકો માનીને સિલેક્ટ ના કરે. પણ this is on a lighter side. See, in their heart, they also want good people. Because once I had the occasion to attend Justice Krishna Iyer's lecture when my father was a judge in small cause court, and Justice Krishna Iyer came to give a lecture outside the old library of Ahmedabad City Civil Court. અને એમણે બહુ સરસ કીધેલું કે good trial court judge, a court of first instance where the suits and criminal matters come, if they are well versed in language, law will be applied. Factual aspect ને grasp કરવામાં જો એ માણસનું સારું જ્ઞાન હોય, if he grasps the factual metrics properly, and if he is having some common sense, the law which he will apply, even if not knowing exactly what the law is, it will be a very sound judgment. And the work of the higher judiciary will reduce considerably. If the judge, he may not be extraordinarily linguist, બહુ ઊંચું હાઈ લિંગ્વિસ્ટિક લેવલ જરૂર નથી, but if he writes simple language, small sentences, if he has clear mind and he writes the facts properly, evaluates the evidence legally, it will be difficult to dislodge such a judgment. So follow the advice of greats like Justice Krishna Iyer. You
જી.
work hard with all consciousness. ગમે એટલો વકીલ ઇરિટેટ કરે, જે તમને બી કરતા હશે ઘણા જજો,
જી સર
જજો
જી જી જી
વકીલોને ઇરિટેટ. Make an impression in judiciary that there are not always bad tempered judges. All try to become nice smiling face judges, but remain firm. People should not take you for granted.
જી
Judges, if you are a higher judicial officer comes, you bow down your head while sitting as a judge. You did not get up, even if he is the Chief Justice of India. But once you are in the chamber, you have to give respect to the post he possesses. One Supreme Court judge suddenly came for inspection, and the judge found out from his face that he is so and so. He got up. The judge scolded him in open court that you are the highest authority in this courtroom when it is in session. Till 11 to 6, you are the master of that court. Even if the Chief Justice of India or President of India comes, you should not rise. You have to simply nod if you can get his face that, oh, here is Mr. So and so. You give a smile back. You nod, but you did not get up. So this discipline will come in handy. Work hard. Don't rise and go inside the chamber to work. If the work gets over, continue to work on dais. There also it is a nice place. મચ્છર હોય નીચે લાલ કપડાની નીચે, એ તો પેલું ઘરેથી સ્પ્રે લાઈન છાંટવાનો.
જી જી સર
એને
જી જી બસ
હા,
સાહેબ એ જ
બોલો.
પૂછવું હતું કે ઇન્ટરવ્યુ પેનલ આજ જોવે છે એમ આપણે જે છે આ બધા જે ગુણધર્મો છે ઈ પહેલા સિવાય શું માંગે છે એમ
મેં તમને
જનરલી એડવોકેટ પાસે
મેં તમને એક સરસ વસ્તુ કીધી. All my father's male juniors became judge.
હા હા જી સર
I
જી
was
જી જી
I was offered High Court judgeship, એટલે મારા ઇન્ટરવ્યુની માથાકૂટ આવે નહીં. I did
જી
not find myself with proper temperament. કે ભાઈ મને એવું ના લાગ્યું કે ભાઈ મારે એમાં જવું જોઈએ. I decided to serve judiciary from outside for raising questions of their behavior, their character, their knowledge, and I am continuing to do that. પણ એ અંદર શું પૂછે છે એ હું કોઈ માણસને દુખી કરીને પૂછતો નથી. એટલે I am really at loss to
અચ્છા
help you on that.
જી સર જી
But if
જી
you
સર
are
જી
well
સર
read, if you are well read, if you give answers with confidence. હું તમને સાદું કહું. When my father came for interview from a small village in Bhavnagar district, High Court judge was in the panel to select small court judge. Out of 52 candidates, 51 were already existing judicial officers. My father was the only one from advocate. And when the judge asked him a question, my father said, "This is not the law." So the judge shouted in his customary style, which my father came to know later કે એની normal ટેવ છે. બૂમ પાડી, "You are talking to a high court judge." એટલે મારા ફાધરે બહુ શાંતિથી જવાબ આપેલો કે for that matter, even if you are a Supreme Court judge and I am talking to you, the law is to remain same. The law is not going to change. If you have the book, give me the book. શાંતિથી book આવી, પપ્પાએ દેખાડ્યું અને the judge appreciated that you have cleared my concepts. So act coolly during interview. Present yourself very nicely. જેટલું આવડે છે એટલું જવાબ આપશો ને તો ઘણીવાર સાહેબને એટલું આવડતું નહીં હોય.
બરાબર છે જી.
Next.
Thank you so much, sir, for your wonderful session. Now I would like to invite Jayant Agrawal, Administrative Head of Sambhav Initiative and Coordinator of this event, for a vote of thanks. Over to you, Jayant.
Sir, thank you very much for such a nice and a wonderful session. You have given all answer in detail without any filter, and this is really great thing. We used to say that people, have some fear to saying things in a very clear manner. So we are really thankful, and also thankful that as a president of High Court Bar Association, you did this program in our collaboration. So advocate from all state, all Gujarat benefited from the same program. Thank you, sir. Thank you very much.
Thank you, Jayant, for inviting me. Have a nice time to all. અને બધા શાંતિથી કોન્ફિડન્સથી તમે બધા જવાબ આપજો, લખજો. અને છેલ્લે ફરી મારો નંબર આપું છું. It is 98252 69434. And Avneet, Hiranshi-ben and Jayant have my number, so they can also share. No issues. Anybody can question without any fear. Anytime. We are there.
Yes, sir. Yes. Yes, sir. Thank you.